In this video, Leah Kiguatha, who is an advocate of the High Court of Kenya, a lecturer at the Kenya School of Law, and an experienced family law practitioner, spent some time with the students from the Community of Practice for Justice Pamoja. I met Leah when we were both students at Georgetown. I was there pursuing my JD. She was there to pursue her LLM. I've stayed in contact with her over the years, and when I was founding Justice Pamoja, she gave me a lot of advice about the most effective model. She wanted to speak to Wakili Wakesho, that is the community of practice for law students at Justice Pamoja, because she believes that law students and young advocates already possess valuable resources. They have knowledge, they have their voices, and early in their careers, they will have the time and the energy, and they can use that to open doors of justice for others. I hope you listen to this conversation in which Leah speaks very candidly about an occasion early in her career when she did not speak up and why she has never forgotten it. We also discuss the barriers that poverty and legal formality create, the relationship between law and justice, and the danger of giving in to despair, and how Leah overcomes that danger. Above all, Leah challenges to recognize the privilege of legal training and to use it in the service of others. I'm very grateful to her for this thoughtful and generous conversation. Who, as I mentioned, is a lecturer at Kenya School of Law. I happen to know her from when we were both students at Georgetown. She was already a practicing lawyer then, but had been invited by Georgetown to come and do an LLM, a master's degree in law. And so I was grateful to meet her during that year that she was in Washington, D.C. at Georgetown. And she, as I mentioned, is currently a lecturer at Kenya School of Law. She previously taught law at Kenyatta University, and she also manages her own firm where she specializes in family law and property transactions. But she has a lot of good insight in both the practice of law and the state of justice in Kenya. And in fact, it was largely based on her advice about the need for mentorship that I thought of this mentorship model for Justice Pamoja, realizing that yes, it might be difficult for me to staff a legal team based on full-time practicing advocates, but that there were students like yourselves who would be interested in getting the experience and who could do very good work provided they um, were given the right kind of supervision. So many thanks to her for that wisdom and also for being with us today.
Thank you. Thank you, Brian.
What was it that shaped you the most?
Because at grade 8, we do a national exam. So I had very good grade. So I was going to be a doctor until I went to high school. Chemistry was tougher than I thought, and biology was tougher than I thought. And I was doing really well I was doing really well in my humanities and my social sciences. But I think also, even at that age, I had a sense for justice. I would find myself often speaking up for the person who looks like other people are disregarding them. And in class, I would, what would I say? I'd like be the devil's advocate. I would raise, when people are having a discussion, when our teachers are leading us through a discussion, I would be the one with arguing a contrary view. So many my teachers and also people who knew lawyers. Don't think I knew any lawyers growing up. There were no lawyers in my social circles except the lawyers on TV. So it was my teachers and people around me who knew lawyers who started to say, you should become a lawyer. And so I took it and ran with it.
I hope that today that we can give people that advantage of just a little bit more of an understanding of what the practice of law is really like. Were there any hard lessons for you, like early in your career? Times when what you studied seemed different from the way that law was actually practiced.
Oh, absolutely. Every day, I I think the law, and that's why we call it practice, because every day something new comes up, something new, and you're thinking, I thought I had seen it all. And then something shows up on your desk, or you're having to handle something, and you realize you had not seen it all. So there will be events where, as I think about it later on, I think I could have spoken up. I should have listened to my gut. I should have pushed with, even if it didn't have, even if I didn't get the outcome I wanted. The just the making the push
Mm.
and speaking up and saying something, even if you don't get the result that you want, then you will have made a difference in somebody's life.
Putting it on the record.
Yes, putting it on the record, it might shift things a little bit. You may not always get the result that you want, but the fact that you spoke up, the fact that you pushed for that person who could not speak for themselves, would really make a difference in that person's life, even when you don't get the result that you want. And so sometimes you have cases which look hopeless, but the fact that you took that person's hand and you walked with them and you encouraged them and you told them that what they were, even if they may not have a strong case, that they have, that how they feel is legitimate. You may not win. You may not always win. Sometimes you win and you get surprise wins, but you may not always win, but it will have made a difference to that person, that somebody
Can
listened
you
to
think
them,
of
that
a
somebody.
Can you think of a particular example in
I can
particular
think
where
I can think of a
maybe someone
particular.
didn't win, but you're glad you spoke up?
Oh, I don't know whether it's the law that draws the kind of personality that's very self-critical. I may not remember the ones. I may not remember the ones I spoke up and it made a difference, but I can remember the ones where I didn't speak up because I thought older lawyers knew better. And to date, some of them were very early on in my career. And to date, I regret not having spoken up. I remember the first, I once, a long time ago, before Georgetown, actually, which means it was, I think, in my first or second year of practice, we were faced with a case where somebody had, some parents had, 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 con- they had, confessed to neglecting their child. They actually went to court and they confessed to having neglected their child. And this child was placed in a government children's institution and then was transferred to a private children's institution because of congestion and the capacity of the government children's home they couldn't handle. And so when these two people were convicted on their own admission of having neglected their child, when they were released from prison, the children officer asked the government children's home for the child, said, give us back, said, these two people have been released, give them back their child. And then the government children's home said, oh no, we gave this child to a private children's home. When the private children's home was told, where is the child? And they said, oh no, we have placed this child with somebody, with a family. And then it became a very administrative nightmare of getting the child out of the family that the child had been placed in. And
Wow.
I remember where I was seated, to date, Brian, I remember where I was seated thinking, if you have on your own admission admitted to neglecting your child, should the child be returned to you, automatically, because you're out? And they hadn't asked for their child. They hadn't asked for their child, but the system was that they need to get their child back. And so I remember where I was seated thinking, we need to fight for custody of this child. The person who's been placed with the child needs to fight for, we need to help them fight for custody of this child so that the child is safe. But everybody around me, government officers, my boss, everybody was saying, oh, she needs to return. The mom who had been given the child needs to return this child. This is their biological child. You can't really fight. Now, even if we had fought, many years later, I had a similar case, and we fought and we lost. But because of that child, because what happened is the child was returned to their original family, and life went on. I went to Georgetown for my master's. Then I came back, and this child had passed on. She had been neglected
Oh,
further, and she died in the hands of her biological family. And I'll never forgive myself for keeping quiet. But at that point, it was my first year of practice. There were older lawyers. They knew what they were talking about. They had been in the system longer. They were government officials. They must have known, about child protection more than I. And I remember where I sat and kept quiet. And I've never forgiven myself for not speaking up for that child. So later on, I had came across a similar case came to my desk. And I fought very hard and I lost. But I'm glad that I tried and that I stood with the child in that situation. So the thing to do is to speak up.
right.
Yeah, you really have to speak up, and it's easier said than done. You see, in theory, it looks like you can, but the law is complicated and so many things come into play and so many factors come into play and we make certain decisions. But I remember exactly where I was seated. And that must have been maybe 22 years ago, 22 years ago. I remember where I was seated and I didn't speak up, Brian. I just thought everybody must know what they're doing. But I remember thinking, we need to, we can't just hand her back. Eventually, maybe, if I had spoken up, maybe they would support around the family. Maybe they would have been, they would, it was not so
Right.
much that she stays in this family, but that systems are put in place to protect her, even as she returns. But at that point, everybody just said, oh, no, you can't. The biological family, the two are out of, and only the two of them and the extended family didn't want the child. So the child was being forced on her two biological parents.
This child was not access to justice. But how would you define that issue of access to justice, especially in Kenya today?
For me, I think access to justice means being able to access services that are already in place for you to be able to resolve whatever disputes that you have in a manner that is fair and with an outcome that upholds your dignity as a human being. So that for me is my understanding of what access to justice is, that there are systems for access for people to be able to access dispute resolution or to access solutions, legal solutions, and that those are available in a manner that safeguards the dignity of those who are seeking seeking that service.
And what do you think about, what is your impression of to what degree justice is accessible to everyone? And, what places, if any, you see deficiencies with regard to access to justice?
I think there are two obstacles to access to justice in Kenya. First and foremost is poverty. When people are poor, it's very hard to access the justice system because the lawyers are expensive, the systems are crowded, there's a high demand and low supply. So where there's poverty, it really makes it difficult for somebody because their priority is the basics. You see, justice can feel like a second or third level need, not a basic need. If you're worried about food, if you're worried about where your next meal is coming from, if you're worried about, you have you're sick or you have a sick person in your family, really pursuing justice is the least of your, it's going to be an issue, but you may not pursue it because you have other pressing needs. So poverty really holds people back in terms of their ability to access justice. And I think another thing is how formal our system is, because the justice system is formal, and yet a huge chunk of the population lives with informality. So a lot of people live on land without titles. You know, they are married in marriages without certificates. They may not have gone to school, and so whatever education they got, even if they went to school, maybe they didn't go to a level where you have a certificate certified.
Mm.
So you don't have formal records of what your life is basically informal. Your transactions are informal. So when you live in a very informal space, and a lot of our population lives in very informal spaces, when you approach a justice sector that requires formality, that requires, if for many Kenyans, actually, the only formal thing they might have is their national ID. And
Right.
only because if you're over 18, you're 19, you're 20 without an ID, you will get arrested. You know,
Mm.
like when the police approach you and you don't have an ID, you're immediately a suspect of being suspected of being a criminal. And so everyone gets their ID. Most people get their IDs at least. But other than that, many people don't have formal anything else that is formal. For a long time, actually, many people didn't even register. The births were not registered. There are people who don't have birth certificates. So now in that sector, in that environment, if the justice system requires you from the get-go to be formal, to have formalities, to have evidence, it can become very, 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 very difficult. And so I find many people shying away from the justice system because to them it's all about formalities. And also the fact that for many poor people, and the connection between the two is that for many poor people, the justice system is purely the criminal justice system. The only time they interact with the justice system is when somebody has been arrested or somebody's in
Mm.
trouble. And so they are, then if that is what you think of the justice system, you may have a right that you want to pursue or an interest that you want to pursue through the justice system. But to you, the justice system is just, it involves a criminal case. And because a lot of normal everyday activities for poor people are criminalized, you don't want to expose yourself. You don't even want to think that you can approach the justice system, because you might approach the justice system seeking a right and then end up being on the wrong foot. So I think it's a combination between poverty and how formal our justice system is, because our justice system is really received. We had our own justice systems, but now those were informal. They were invalidated until recent attempts to incorporate them into the justice sector as alternative justice and alternative dispute resolution.
Right. Right. Do you think there is a place, if any, for traditional justice systems? So, I mean, I think that we can think of probably many examples where, and especially with sex and gender-based violence, which is the focus of the work of Justice Pamoja, where the traditional justice system often does a bad job of giving justice. Um, would you agree with that? And if so, what are the possible solutions?
I
Well,
personally worry about it. And I've just retired from the board of FIDA. I served one term and I didn't offer myself for re-election. And at FIDA, we are really working hard on incorporating alternative justice systems into our work. But I must say that I worry very much about the how patriarchal norms influence alternative justice systems. And I know like the executive director and the deputy executive director at FIDA has really tried to convince me that in the system as it is currently set up, and one of the judges who is fronting it on the judiciary side, Justice Professor Joel Ngoge, is an amazing, amazing thinker. All his judgments are really, really pro-equality, pro-dignity. The ones that I have read, every time I read a judgment of his, I think, oh, wow, he has really thought through it. And so he's at the forefront of that. And so I personally worry about whether the patriarchal norms are not too embedded in the alternative justice systems, but the people who are working on it now, and there are people who I have massive respect for, tell me, but I haven't had myself much experience with it, but tell me that every effort is being made to ensure that the elders include women, and that the constitutional norms are upheld, and that dignity is upheld, that equality is upheld in the application of alternative justice systems. Because the idea is to open up the availability of access to justice to ordinary people, because apparently a big chunk of people don't approach it. So I worry about whether it's possible to, to delink it from the traditional norms that held down and oppressed women for long. But the people I'm speaking to in that sector keep saying that everything is being done to ensure that dignity is upheld and that equality is upheld, and that it is not used as yet another tool of oppression. So those are conversations we could actually pursue as Justice Pamoja, to see how we could. I think we should spend some time listening before we make up our minds about it. Because for me, I can tell you, I have a personal discomfort, because I always imagine if the traditional norms are followed, most likely thing is that women and girls and junior men and boys will end up being, will end up being the victims of the stronger party, who is usually a man.
Right.
Yeah.
Right. So in talking to you, I mean, it's clear that yes, the law is your profession, but justice is your passion. You felt as a schoolgirl. Just do you want to talk more about what justice really means to you, or what motivates you, or
one of my favorite passages of scripture, and I realized it's been a favorite for a long time. I came across a brochure I had done. I worked for my church for 1 year full time. After, in between, I don't know if currently people do. Yeah, they do. Okay. In our time, we did pupillage. We did not go to Kenya School of Law. You see now what's going to happen with the students is that you finish university, you do Kenya School of Law for a year, then you do pupillage for 6 months, and then you wait to be admitted to the bar. In our time, we would just go straight to pupillage because we were exempted from Kenya School of Law. Sorry to the students who are listening. For us, we didn't have to go to Kenya School of Law. And I saw a brochure I had done for the year that I was working in church, and it had this scripture, so it's been my scripture for long, and I keep going back to this scripture. I was quoting this scripture the other day to a pastor who had preached a sermon saying that all Christian lawyers who do divorces are going to hell. So the Christian Lawyers Fellowship invited him for a discussion.
Okay.
And about that, because we said, what is he talking about? So anyway, it's Isaiah 61. The Spirit of the Lord God is upon me. The Lord has anointed me to bring good news to the poor. He has sent me to bind up the brokenhearted, to proclaim liberty to the captives, and the opening of the prison to those who are bound, to proclaim the year of the Lord's favor and the day of vengeance of our God, to comfort all who mourn, to grant those who mourn in Zion, to give them a beautiful headdress instead of ashes, the oil of gladness instead of mourning, the garment of praise instead of a faint spirit, that they may be called oaks of righteousness, the planting of the Lord, that he may be glorified. They shall build up the ancient ruins. They shall raise up the former devastations. They shall repair the ruined cities, the devastation of many generations. This for me is really a life verse that is intertwined with my work. Because every time somebody comes to me and they are broken and they are, they are desperate and they want what they need, and what I need is to bring good news to them. They don't have to win, but to bring the good news to them, to bind them when they are brokenhearted, to proclaim liberty to them in whatever captivity they are held as they seek legal services and as they seek justice, the opening of the prison to those who are bound, to proclaim the year of the Lord's favor and the day of vengeance of our God, to comfort those who mourn, to grant to those who mourn in Zion, to give them beauty for ashes. I think that's how we sing it in a common hymn. Oil of gladness instead of mourning. I think as lawyers, we really have an opportunity to do these things in Isaiah 61 just by doing our work, just
Right.
by doing what we know how to do that other people do not know how to do. Just by filing that case for somebody, by helping them with their defense, by helping them with their case, whether they win or they don't win, you will have done what Isaiah 61, what the Lord has empowered you to do, as he promises in Isaiah 61.
Passages
Mm-hmm.
emphasize the duty of a king, or in these days, a government, to
Mm-hmm.
protect its people, to ensure that justice is impartial. And there are, of course, so many accounts, both long ago and today, when kings and governments do not fulfill that duty, and then it falls on others to remind the kings and governments to how they can do a little bit better job. So I hope that we all have some role in that, regardless of exactly how we understand the story. I've been working with Justice Pamoja. So what advice would you give to people working in this area about what they should be careful about?
The thing to be careful about first is to really, really encourage the students to do this work. This is the best time to do it. Get started on it, get experience, learn how to do this and commit to doing this. I have said for a long time that I wish we could get lawyers in especially the first 5 years of practice to do pro bono work. Dedicate yourself to do pro bono work, because in those first 5 years, what you have is you have time. You may not have a lot of money, but you have time. Between 1 year and 10 years, maybe five if, as a minimum, maybe 5 to 10, keep doing keep giving your time. Now, from 10 years of practice onwards, we understand the pressures of life come. You could still keep giving your time, but maybe at that point, what you could do is maybe lend support, lend money, support the work through money, and also through lending your experience, even if you may not have a lot of time, because you do run out of time. And between I say between year 10 and 20, maybe that's the time you send your associates to do the work. Support it with money if you can. And and even over and above that, with your expertise and your money. But in the first 10 years, really, really, you have time. And if you can give it to to doing pro bono work, you'll never regret it. I think the thing to watch out for is a feeling of despair and a feeling like you are not going to make a difference, like it's not making a difference. Is to watch out for that feeling of despair or feeling like giving up, like the system will never change and maybe you need to not do it. That I think is the thing to look out. And of course, also really look out so that you don't yourself become the villain. You don't re-traumatize a person who has come to you looking for a solution and looking for help. I think those are the two key things that we need to look out for as we go into this work. But I say, students who've started on this, well done, kudos. You have skills, you have information, you have knowledge that as lawyers, it's such a privilege to have. And going into the future, going out into the public, people don't have this knowledge and this expertise that you already have just by attending the law classes that you have attended. And then when you're admitted, you have a right of audience before court. As a right, you have a right for the court to listen to you when you go to court. You are able to open those doors of justice as of right because you have been admitted to the bar. So it's a position of massive privilege and a position that it is, these are resources that very many people don't have. If you can use them to help, if you can give your time in the first 1 to 10 years before life goes crazy, and it will be time that you spent very well and that you will never regret. I remember doing a pro bono case for a child and that case was in Makadara. I think about it now and I think I'm so glad I did it because years later I would never have the time. I remember going to Makadara over and over again, sitting in, and this boy had been charged with stealing a mobile phone. And at the time, my church ran a halfway house. So after he was, in fact, I argued on a technicality. He was released on a technicality. I remember how I was quoting. That law was later said that the director, because it was a regulation that said if a child is charged, I don't know if that's still the case. I haven't done a child's criminal case for long. That if a child is charged and 3 months from the date that they took plea, their case has not proceeded, you must discharge them. So I went for the first mention, then I went for the second mention, and I think on the second or third mention, I just told the court, you have to discharge this child according to the rules. And I remember the court saying, what? And the lawyers around me saying, what? And asking to show them the rule. And the rule was in the act. And so the magistrate was really told off the guy. She told him off, you're being let go on a technicality. If you're arrested again, da, 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 da. But I let him go and he went into a halfway house and then he ran off. He disappeared. But I still don't have any regrets because at that moment, I fought for him. I spoke for him and he was released. I wonder whether he's still stealing phones 20-something years later. I really hope he's not. But I'm so glad because when I think about it now, there's no way I would go to Makadara 3 or 4 times for no pay because I have salaries to pay, I have rent, I have kids to educate. So I can't.
Right.
But in those years, I had all day. I remember sitting eating mandazi in a kiosk with my friend, with my friend, with my friend whom you must meet, Brian. So she she was running the Kenya Christian Lawyers Fellowship, the clinic there at the time, and we would go and represent those kids. And I think I can't imagine finishing court and going to take a cup of tea and mandazi because now I ran out of time. But in those years, I had a lot of time, and so I'm so glad I used those. That is what I did with those years. So you have time. It's a resource. It's something you have in your hands. Give it. You will never regret actually doing that work. in the early years when you still have the time. Because I also used to imagine that the Lord will ask me what I did with my 20s when I was single, wanting to get married, but I was still single. So I thought the Lord will one day ask me, those years I gave you when you were single, as you waited for me to get you a family, what did you do with them? And I'm so glad that I spent them in the way that I did.
Yes. Yeah. Thank you. That's very inspiring. I'm sure for the students and even for me. But all right. Why don't we now open up the floor for anyone else who has a question? Remember what Miss Kiguatha has said about this is your opportunity to speak up, to be heard. You will regret it if you do not take this opportunity.
20 years later, you'll
Yeah,
be
you'll
thinking
regret it.
about it.
That question that you had, yeah, the opportunity to ask.
Maybe there are no questions, Brian.
Um, what you've talked about is really insightful in terms of us using law in service of justice. Um, and it's very important that we make sure that that does not switch. So I guess my question is, how do we ensure, or rather, what can we do to really ensure that that pendulum does not swing the other way, and we're using justice to serve law, because it's a very hard thing that you are doing, especially the older advocates in the field,
Mm-hmm.
in quite involved in matters of like legal aid and pro bono work. So how do we try to kind of maintain that like balance or reconcile that? Yeah, thank you.
You know, as a lawyer, you first your fidelity is to the law, and then your fidelity to the court and your fidelity to your client. Okay, so you really must fight for your client. I'm not saying don't fight for your client. If you go in and maybe you become a prosecutor, your client is your client is the prosecution, and you just have to do what you must do for your client, but remember you still have fidelity to the law. And you will find actually we always imagine that we will always be in a conflict between the law and justice. You will find that apart from once in a while when the law is crazy and you're really trying to fight, there are many times you'll find unjust laws. And then in those cases, you must fight for justice and, if possible, for the law to be changed. But remember, even as you represent your client, you have fidelity to the law. And what that does is that it enables you to advise the client. On this one, the law is not on your side. We'll fight for you, but just know that the law is not on your side. Then you're able to be honest with them because you have fidelity to the law. And remember, for example, in a criminal case, your duty is to fight for your client and still to have the law upheld. The duty, the burden of proof lies on the prosecution to prove the case against your client. So you have a duty to your client, you have a duty to the law, and you also have a duty to justice and to the courts. So it's a balance, but will actually find that in many cases it's not as convicting as you might think that it is, except in instances where there is a need for law reform. Usually, if you follow the law, you will be on the side of justice. There are some circumstances when, of course, it is the law that needs to change, especially we find that laws are very skewed, can be very skewed against the poor. And in that case, you must think Isaiah 61 about how can you bring good news to this person, even in the way that you help them to find relief, to find a solution in the law. You see, like that boy that I fought for, I used the law. Later on, that law, by the way, the court said it was the director of children's services should never have done that regulation, that regulation was, he had gone outside of his powers to do that regulation because it was not in the Parent Act, the Children Act. But that's what I use the law to fight for my client. So you will, as a lawyer, you use the law to fight for your client. There will be instances where you need to fight for the law to be as it should be, but most instances you will be able to fight. In most instances, you'll be able to fight for your client within the law. Oh, there's somebody who has asked a question. What is that one case that you handled that made you proud of being in the family law field? So many, Esther. Every day I handle cases to date that have made me proud in being the family law field. You know why? Because one of the mandates that we are given in Genesis is to subdue the earth. It's to subdue the earth. And when people are in a family law dispute, the earth is not subdued. So when they come to you and you help them find a solution, you help them find a solution in their custody matter. You help a child who is an abandoned child be secured in a family. When you help people hammer out mediation agreements in their family, settle issues around their succession, it helps you. You realize what you are doing is subduing the earth, because people come when they are when everything is all over the place. The earth is formless. It's things that it looks like there is no solution. But when you hold their hand and you help them find, it may not be, Esther, they may not find 100% peace, but they find a solution. They are able to crank out. They are able to, the court gives them a custody plan. The court makes a plan for the children to be provided for. They came in a state of chaos, and you may not have created 100% peace, but you have created a semblance of peace for them, a solution to their problem. When somebody is in an abusive marriage, or they have been abandoned for years, and they are stuck in this institution without a relationship, and you do the case for them, and you help them to be released from that situation, you have done some Isaiah 61 work, and you have done some Genesis 1, Genesis 2 work, where you have helped them to subdue the earth, because the earth is always fighting back. And as lawyers, we have an opportunity to subdue the earth for people. Not 100%, because 100% is when the Lord returns. On the other side, then everything will be perfect. But you are able to introduce a semblance, a degree of peace, a degree of their situation being subdued and no longer being in a state of chaos and flux. So many. Last week, I hammered out a mediation for some clients who are really, really, really fighting. It was so stormy, I almost gave up. Actually, what I did, and I know, is bring in another mediator to help. And it looked like there was never going to be a solution to this problem. They were so far apart in terms of what was going to happen with their co-parenting of the child. But finally, we worked, and we had a final meeting when they signed off, and they have a solution for how they are going to go forward in co-parenting. Yet at the beginning, it looked like these two would never. I kept thinking one of them is going to go to court. One of them is going to go to court. But we subdued the earth. So there are so many, it's hard to pinpoint a specific one, because almost every day you're involved in cases where you are glad that you know that you're subduing the earth for people with family law dilemmas. Even when you do conveyancing, Somebody wants to buy, they are purchasing a property, or they are selling a property, and they're afraid of being conned, and they are worried, what if I give this person my land and they don't give me the money? Or what if they, what if I pay and I never get the land? And then you come in as a lawyer, you craft an agreement and you structure that transaction so that everybody is secure. The money is secure. The person buying knows the money will move when they have title. And the person selling knows they'll get their money. They'll not lose title without getting their money. You've subdued the act. Because for them, when they come to you, they're thinking, how do I make sure that I do this in a way that I don't get conned? And you do it for them, and you do it well, and they each go home. The seller gets their money, and the buyer gets their title. You have subdued the art for them.
Yeah, I find it a very inspiring answer, what you're saying about subduing the earth. We often talk about a real division between criminal law versus civil law, and Justice Pamoja sort of focuses more on things that are criminal matters.
Mhm.
Uh, but I wonder how many of these that often physical violence could have been prevented if the parties had been able to avail themselves of someone like Leah who could help them. Like, people are always going to have disagreements. We don't expect that people will all see things the same way. But what a functioning justice system can do is mean that when people have a disagreement, instead of resorting to violence, they can trust that the civil justice system will give them an outcome that feels fair and respectful. Even if they don't get exactly what they want, they can trust, okay, my rights will be respected. So that is the way I should go instead of resorting to violence. So, but just from what I hope you just heard, there's a way that all law is human rights law because you are giving human beings a respectful way of resolving their conflicts. Time to give our great gratitude and thanks to Leah Kiguatha. She's really shared a lot of great information with us today, as well as insights about the practice of law. Frankly, they are insights that I wish that I had been able to hear as a law student or as a new lawyer. So all of you should feel grateful to have heard them today. And I hope that all those of you who will be joining the Kenya School of Law in the next couple of years, you know which lecturer to look for, and to look for the opportunity to join her courses. Thank you so much for being here with us today. And yeah, again, thanks for all the advice that you've given me as we started Justice Pamoja. And I look forward to many future conversations with you.
Asante sana. Thank you.